What does a patent let you do, or what does a patent allow you to do? I think you'll be surprised by the answer, so be sure to stick around. For those of you who are new here, my name is Dylan Adams. I'm a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You also might recognize me from my appearance on CNBC's hit show, The Profit, with Marcus Lemonis. So this channel is all about giving you the insider tips on how I protect my clients, protect their ideas and inventions. And those folks range from Fortune 100 companies to startups to Shark Tank businesses. So be sure to subscribe and hit that little bell icon so you get notifications when new videos come out. All right, let's go ahead and get right into it. So what does a patent let you do? And it may be surprising that patents really actually don't allow you to do anything. What they actually are is an exclusionary right. So patents actually give you the ability to exclude others from doing certain things, specifically making, using, selling, offering to sell, and importing the claim device into the United States. That's assuming you have a United States patent. And that's another important thing, is that patents are very jurisdiction by jurisdiction. So if you want to stop people from doing things in the United States, you need a United States patent, but that doesn't apply to China or Australia or Korea or Canada even. Each jurisdiction has to have its own patent in order to have protection there. So an example would be, if you have a product that is being manufactured in China, they can totally do that if you don't have a Chinese patent. But if you have a United States patent, you could stop them importing it, because United States patents allow you to stop folks from importing goods in addition to making, using, selling, and offering to sell them within the United States. But for internationally, you have to get a patent in each jurisdiction. So again, if you want to stop somebody from manufacturing stuff in China, you need a Chinese patent. If you want to stop them from then being able to import that into Canada, you would need a Canadian patent. Or if you want to stop somebody from manufacturing in Canada, you would need a Canadian patent. So that's another important thing about patents, is it's only jurisdiction by jurisdiction. Now the negative right is worth going over, and this is where a lot of people get confused when it comes to patents. They think it gives them a right to actually do a certain thing. And again, all you are able to do is exclude others from doing things. Again, it's making, using, selling, offering to sell, or importing what you have patented. And let me give you an example of kind of how this works. So let's say you were to get a patent on a drug for treating cancer, or a method of treating cancer with that drug. You don't have a right to actually use that. The patent doesn't give you that right. You would probably need FDA authorization to be able to actually manufacture the drug and use it for its intended purpose, right? So you don't actually have the right to do that. Again, patents allow you to exclude others from doing things. Now, how do you actually exclude others, and how do you determine what you can exclude others from doing? The first thing to note is that you can only exclude others when you have an issued and enforceable patent. And how do you get an issued and enforceable patent? So let's step back and kind of talk about the patent process. So to get a patent, you have to file a patent application. And the typical way is to file a provisional application, or you can file a non-provisional application. And I've got some good videos about provisional applications versus non-provisional, but the application that will actually mature into an issued patent is what is called the non-provisional patent application. So you draft that patent application, you file it at the United States Patent and Trademark Office, and then it waits in line for a long period of time, usually 1 to 3 years, because, well, it's the US government, everything takes a long time, they're super backlogged. So after 1 to 3 years, it's picked up by a patent examiner at the United States Patent and Trademark Office. And this patent examiner is going to do a prior art search. And the prior art search is going to try to determine whether what you have claimed is new and non-obvious compared to things that are already out there. That is the prior art. And what is prior art? So prior art could be really any sort of technology disclosure. One of them could be existing patents that are issued. It could be pending applications that are published, but really any technology disclosure. It could be a blog post. It could be a YouTube video. It could be an actual product in a catalog. It could be, really even a scientific paper. I mean, any sort of technology disclosure could theoretically be used against you in the examination process by an examiner to say that what you have claimed is not not new and is obvious compared to the prior art. I would say probably 95% of the time it's going to be published patent application or issued patents that are asserted against you during the examination process. But every once in a while, I'll have like a YouTube video or an old web page cited against me during the patent examination process. So prior art can really be anything. So there's this negotiation with patents, and it's important to keep in mind the patents just aren't a binary thing. It's not just you have a patent or you don't. They provide potentially a spectrum of coverage. You can have a patent that is really, really broad and covers a lot of different variations, and those patents can be really valuable. Or you can have a patent that is so narrow and so specific that it's almost essentially impossible to infringe, or so easy to design around by making little changes, intentionally or not, that it provides little protection or value at all. And that's something that's really important to keep in mind about patents. Is it's important that you're trying to get a broad patent. Really getting an issued patent isn't really the ultimate goal in a lot of ways. You're trying to get the broadest patent possible. And the way you get the best patent possible, the broadest one, is through negotiating with the examiner. And just like, say, an episode of Pawn Stars or American Pickers, where there's this battle between the buyer and seller trying to get to a price that they can agree on, it's similar with the patent examination process. So you start with a set of claims that defines what you want to have protected. And a lot of times you'll go in with an offer that is broader than you're probably entitled to. And then the examiner will cite prior art against you, and then you'll have to narrow the claims and make them more specific in order to get over the prior art rejections, differentiate over the prior art, to show that it's not obvious over the prior art, or it's at least novel over the prior art. And so you go back and forth with the examiner. They send you an office action with objections. You may amend the claims or argue and respond to that office action, and that can go back and forth a few times, and hopefully you convince the examiner that what you have is new and non-obvious, and then your patent application will issue as a patent. That's when you have enforceable rights. A patent is typically going to be enforceable for, utility patent at least, is going to be enforceable for 20 years from the filing date of the non-provisional patent application, but that can be extended or that can be less in some cases. Sometimes you have to get over certain rejections in certain applications, you have to cut off the term of a patent, or if the patent office is really slow in the examination process, they can actually extend your patent term sometimes. So, but generally the thing to keep in mind is it's going to be about 20 years from when the patent application is filed. And so, like I said, so you have to have an issued and enforceable patent to be able to exclude others from making, using, selling, offering to sell, or importing the technology into the United States. And the patent is only going to be valid for that 20 years from the filing date, but you also have to pay maintenance fees for utility patent applications. And that is also required in order to keep them alive. And that's something that people sometimes don't check on is, oh, well, this patent is issued, but well, maybe they didn't pay the maintenance fees and it's expired, or maybe it's past that 20-year deadline and it expired, or maybe it doesn't, the term doesn't actually last for 20 years and it actually expired before that. So again, it has to be issued. It can't just be a pending application. It can't be just a provisional patent application. It has to be an application that has gone through the full examination process, been allowed, and then issued, and then it still has to be enforceable by paying maintenance fees and still being within its term limit. So how can you tell what you can exclude others from making, using, selling, offering to sell, or importing? And this is something that also really confuses people. Is it what's in the description of the patent? No, it's not. Is it what's in the drawings of the patent? No, it's not. What defines the metes and bounds of what you can actually exclude others from doing is defined in this weird section at the end called the claims. So the claims, they're going to be these one-sentence things. There's usually going to be about 20 of them. There are going to be these numbered sentences at the very end, not to be confused with the numbered paragraphs or the column numbers in an issued patent. The claims are what actually define the metes and bounds of what's protected. And one thing that confuses a lot of people is they see something in the drawings and they assume that that's something that the patent could potentially exclude people from doing, or there's all this stuff described in the description or the specification. People assume that everything in there can be, that it can be used to exclude other people. Not the case. Like I said, keep in mind, patents can be really broad or narrow. And if it was just a binary thing where, hey, the drawings and the description, that's how you define what what you could exclude others from doing, well, then it really would be simple. There wouldn't be this gradient or spectrum of protection that you have. The spectrum of protection is the difference in the claims, the way the language is. You can have claims that are really specific to one very, very specific thing that is easy to design around or that nobody would ever potentially infringe on. Or you can have claims that are worded in a way where they're really broad and it's easy to infringe on, right? There's a lot of variations that are described by these claims, and so then the patent is a lot more valuable because it creates a big moat around what you're doing. You ideally want the patent to protect the product that you have, but you want it to protect a lot of variations. I mean, sometimes, yeah, people are going to knock off your exact product, but a lot of times, realistically, they're going to make some changes to it, or maybe they're going to try to improve on it. You ideally want to have those covered in the claims. So that's the important thing to note, is that it's not just the drawings, it's not the description. Some stuff in the description and the drawings, that has to be covered because the claims have to be within the scope of what the specification and drawings show. But by and large, it's going to be a subset of what is actually in there. And sometimes it can be a really, really small subset of what's actually in the description and drawings. Maybe it's just one figure out of 20 or 30 that's actually protected. So you have to read these really, really confusing claims. And that's the unfortunate thing, is it's not really easy to do. It's not easy to parse these claims and understand how to determine infringement versus non-infringement from these things. And that's why patent attorneys get involved, because patent attorneys understand the law and how to interpret claims. But I do have a good video that describes all about claims and the kind of more detail on that. Be sure to check that out. And if you're getting value out of this video, if you find it useful, give it a thumbs up. We'd really appreciate it. And if you're looking for more insider content on patents and startups, click the subscribe button and that little bell icon so you get notifications when new content comes out. And I'd love to hear what your thoughts. Do you have any questions about this? Were you confused about anything? Does it raise new issues for you? And have you ever been confused by any of these things? Is there anything you'd like to know more about in terms of, say, claims or the description, how those things are interrelated? Do you have any suggestions for additional video topics? I would love to hear from you down in the comments below. Let me know what you think. And thanks for watching. Really appreciate it. We will see you again in the next video. Cheers.